as soon as possible imposes a constitutional obligation of urgency, immediacy, and expedition, so that a bill is not held up for want of assent. The constitutional mandate to act as soon as possible necessarily implies the mandatory character of the action. Granting the governor any discretion would render this constitutional expression meaningless. The nexus between withholding of assent and the first proviso is further evident from the expression, the governor shall not withhold assent therefrom at the end of the first proviso. The first proviso begins with an urgent mandate to the governor to return a bill to the House for reconsideration in case assent was withheld in the first instance. Thereafter, the House is expected to deliberate and decide whether the bill should be passed again. And finally, in case the bill is passed again, the governor is mandated to not withhold assent. This implies that the initial withholding of assent is conditional and tethered to the duty of the governor to necessarily return a bill for reconsideration as soon as possible, followed by the duty of the House to reconsider and pass the bill if it so wishes, and the duty of the governor to necessarily assent if the bill is passed again. The Union of India has relied on the word may. Please, my lord, for a moment look at that. The Union of India has relied on the word may in the first proviso to contend that it is not mandatory to take recourse to the first proviso in case of withholding of assent. It is submitted that the use of the word may denotes that the first proviso shall be applicable only when assent is withheld by the governor. The use of the expression may was necessary, keeping in mind that the governor must exercise one of the three actions when a bill is presented for assent. That's why, my lord, the word may, because he can do one or the other. Therefore, may. This understanding has been rightly affirmed in state of Punjab and state of Tamil Nadu. The union has also contended that the governor has an independent option to reserve a bill for the president's consideration after it is repassed by the legislature pursuant to the first proviso. However, this contention is unsustainable, as the five-judge bench in Valluri Basavaya held that the governor was bound to give his assent when the bill is reconsidered and passed by the assembly. My lord, there's no question of sending it to the president after that. So, my lord, this is held in these two decisions. Even otherwise, the expression shall not withhold assent necessarily means that the governor must assent. By contrast, Section 24 of the Government of NCT of Delhi Act expressly allows the lieutenant governor to declare either that he assents to the bill or that he reserves the bill for the consideration of the president. My lord, in para 62, I have pointed out which are the provisions where the bills have to be reserved on ministerial advice by the governor for president's consideration. I've listed out, my lord, all those articles in para 62. My lord, these are the articles in the Constitution.
Again, according to that, is to be only on the aid and advice of the cabinet.
Only on the aid of it.
Not in his own discretion.
Yes, there's no discretion, my lord. So he has to, this is the way, my lord. In fact, my lord, rules of business are incidental, may I say, transaction rules of business. But your lordships will find both the union government and the various state governments in their transaction of business rules under 166.3, 77.3, all have provisions, my lord, of how bills, who processes the case when it has to be reserved for the president or for the governor. They have, my lord, specific rules, but they are rules of business. I'm going by the constitutional provisions. My lord, please see. So, my lord, this is on ministerial advice. Now, please come to bill falling through. My lord, this bill falling through was an important part of the argument. My lord, bill falls through means, my lord, it is not passed again by the House. It falls through. It falls on the floor of the House. My lord, if one were to use that expression, something falling through, it goes straight to the floor. That is what that expression falls through means. That if you don't act in accordance with the first proviso and bring it back to the governor for assent, it's gone. It's just fallen through. It has failed. Now, my lord, the judgments in Kameshwar and Valluri Basavaya text conclude that the governor may withhold assent, in which case the bill falls through unless the procedure indicated in the proviso is followed. As has been rightly held in Tamil Nadu, the words bill falls through do not suggest that the governor may simply withhold his assent to a bill. A bill would only fall through if the legislature, upon a remit for reconsideration, chooses not to pass the bill. Then, my lord, we come to timelines. I now come straight away to timelines. At the outset, it is submitted that questions 5 and 7 of the present reference are premised on a factual statement that Article 200 does not stipulate any time frame upon the governor for the exercise of constitutional options under 200. It is respectfully submitted that the question fails to appreciate that the expression as soon as possible in Article 200 is a term of art and that imports a sense of immediacy mandated by the Constitution. The expression as soon as possible informs the exercise of all three courses of action under Article 200. This understanding has been recognized in these three judgments. It is submitted that the prescription of timelines is necessary to enable access to courts and judicial review. My lord, the timelines in the judgment were for coming to the court. They were not, my lord, timelines imposed on a governor or the president. They were only guidelines to regulate when would judicial review become available. It is submitted that the prescription of timelines is necessary to enable access to courts and judicial review. In Tamil Nadu, the prescription of timeline was considered essential for the exercise of judicial review, since it provided a set of definitive standards against which courts can embark upon their scrutiny. It therefore serves as a guideline for the courts to exercise restraint and wait for the prescribed period before entertaining a challenge to the inaction of the president or the governor. It is also important to distinguish between prescribing a timeline for the purpose of judicial review and prescribing a timeline for the purpose of deemed assent. My lord, the judgment in Tamil Nadu does not talk about if you go beyond the timeline, there's deemed assent, not at all. For instance, in the United States and Singapore, the expiry of prescribed timelines automatically leads to deemed assent. By contrast, the expiration of timelines prescribed by Tamil Nadu does not lead to automatic deemed assent. It merely enables courts to review instances of inordinate delay. That's, my lord, the only way, that's the limited way in which it has to be read. It is further pertinent to highlight that the timelines in respect of Article 201 were adopted from timelines prescribed by the Ministry of Home Affairs in their office memoranda. So, my lord, they did not come artificially. They took, my lord, they saw the office memoranda. It is submitted that the phrase as soon as possible imports a sense of immediacy mandated by the Constitution. However, if this is found to be ambiguous, the expression may also be construed to mean forthwith. This understanding is confirmed in the deliberations of the Constituent Assembly. The words as soon as possible were understood to place a strict obligation on the president to act with a sense of immediacy. My lord, Purushottam Namboothiri is in a different case. It was on the existence of a legislature. Your lordships can peruse it at convenience. I now come, my lord, to justiciability. Para 73. It is submitted that judicial review and justiciability are two sides of the same coin. The distinction is one of procedural nomenclature. Justiciability concerns the discovery of manageable standards, while judicial review is the process by which these standards are applied and enforced. Together, they ensure that all constitutional authorities, including the President and the governors, act within the limits imposed by the Constitution. In Bommai versus Union of India, well, I must mention that although Justice Jeevan Reddy's judgment refers to a your lordships mentioned it to my learned friend, the Solicitor General. There are many passages in that judgment which suggest some sort of even in a quasi-federal setup, there is a strong centrist bias or unitarian sort of bias. But, my lord, the learned judge, has carefully said even then, for the purpose of governors' actions and the state legislatures to function untrammeled by powers of oversight, it is necessary that they must have independence and judicial review must exist. But my lord, when your lordships mentioned that to my learned friend, the solicitor, I immediately recollected those passages. Then, my lord, please see, in Bommai, this court held that when powers are entrusted to a constitutional authority for achieving a particular, Well, one of the advantages of sitting here is also noting down the observations and then reflecting over them. Because many times, my lord, in the process of any submission, one takes note of all the observations of learned judges. They actually form the cue. They form very useful cues to understand what is actually engaging the attention of the court.
Advantage would not have been available to you if you were somewhere else.
I agree with that.
Because on screen it is not that.
Often because of the space constraint, we follow the screen.
But not as minutely as one sitting here.
And then, my lord, please see.
Mr. Tushar is not aware of the context.
I know.
In Bommai, this honorable court further held that the amenability of the power under 356(1) to judicial review is beyond dispute, as the court is entitled to examine whether the condition has been satisfied or not. It is respectfully submitted that the union has placed reliance on the minority judgments in the said decision. My lord, both Justices Ahmede and Ramaswamy give it the minority. My lord, when the Solicitor General finished his submissions, I followed a tradition in this court. My lord, we always walk across to the place where the lawyer has finished and congratulate him. My lord, I observed it in this case because there was so much of industry. And I must say, my lord, while I disagree with the submissions, but my lord, I marvel at his industry and perseverance. Further, like all other authorities, the President and the governors are bound by constitutional limitations. This court has consistently held that no exercise of constitutional power is immune from judicial review. My lord, this is Madhuram, BP Singhal, then my lord Perarivalan, then my lord State of Rajasthan versus Union of India, and State versus Tamil Nadu. Then my lord 163(2), my lord, is not a bar to judicial review. My lord, the next few paras, they deal with this. But para 83, my lord, is important because it was in SP Gupta that the judges said that 74(2) still does not prevent us examining the material and the reasons in support of a decision. So, my lord, the bar of scrutiny from the court under 163(2) is limited. 3 and 74. Now, please see then, my lord, next one is Article 361. My lord, I have also dealt with it. I then come to deemed assent. My lord, that's para 86. It is respectfully submitted that in the state of Tamil Nadu, this honorable court, in exercise of its powers under 142, invoked the principle of deemed assent in respect of 10 bills which had been kept pending before the governor. The declaration was made having regard to the peculiar factual matrix of the case and to secure compliance with the constitutional mandate while maintaining the institutional dignity of the governor's office. This honorable court, after reviewing the events that had unfolded, concluded that the governor's conduct was lacking in bona fides and marked by repeated failures on the part of the governor to show deference to binding directions of this honorable court. That this court held in the circumstances of the case, it would be difficult to repose trust and remand the matter to him with the direction to dispose of the bills in accordance with the law laid down in the judgment. It is submitted that in the facts of the case in Tamil Nadu, this court's actions were warranted and are indeed commendable. They maintain the dignity of the office of the governor by preventing a situation where actions of a governor may have been subject to judicial comment. These directions also maintain the dignity of the office of the governor. Now, my lord, I come to the next portion. I'll sum it up, my lord, in a few words. My lord, the only decision which has taken a view that in a presidential reference, one can overrule the law is in the 2G case. That's the only judgment. It relies upon, my lord, a passage of Chief Justice Chandrachud in Re Special Courts Bill. That passage, my lord, was in a different context. The question was whether the opinion rendered by the Supreme Court is binding on all the high courts in the country and the Supreme Court. It said, yes, perhaps we cannot bind ourselves, but it will definitely be binding on the high courts. In fact, my lord, the para which is accepted by Justice Jain, and I say with humility and respect, actually does not read the entire para in Special Courts Bill, because the last portion of that para is where Justice Chandrachud says, we are not unmindful of what a learned author, Kapil Sibal, said in his book, that these only have high persuasive value, but do not bind because they are not emanations of 141. It was in that context, my lord. So, my lord, I submit with respect, it is not a correct position to assume that a judgment can be overruled in a presidential reference. It has to be done, my lord, through normal adjudicatory process. My lord, there was one point which the learned Chief Justice asked us on the first day. It was a very important question. What happened to Article 1? Sorry. Your Lordships asked, what happened to Article 145.3? My lord, if your Lordship sees Article 145, well, except for Article 143, all the other articles from 123 onwards, right up to Article 145, they all deal with the powers of the Supreme Court. All the powers of the Supreme Court are adjudicatory except for 143. My lord, Supreme Court has complete powers. And my lord, those powers have to be read with 32. 32 itself, my lord, can be writs for any purpose. So 32 plus 142 plus 141 plus 144 plus 139. My lord, there's a provision in our constitution where your lordships have what are called ancillary powers. Your lordships would have seen those provisions. So it's a unique institution endowed and blessed with enormous power to be able to adumbrate on law and also, my lord, ensure that complete justice was done having regard to the facts of a particular case. My lord, there is an appendix to my written submissions, which your lordships will find. It lists out all the provisions of the Constitution where, my lord, the governor functions only on aid and advice of the Council of Ministers. My lord, I am extremely grateful. It's at page 1280.
Yes, yes, in that. Yeah.
My lord, I am extremely grateful.
Why isn't there the second appendix where those provisions are?
There's only one appendix, my lord. Sorry.
Saying those which are identified by the constitution.
Yes. Well, the
At least
others
you had a
I have
second
identified
appendix.
in the note. I can put it in an appendix also for the sake of comfort. Well, some debts of acknowledgement are due. I must do it. First is, my lord, debt of acknowledgement to the court for having given a most wonderful opportunity of hearing, consideration, and reflection. It has been, my lord, a distinct honor and a great privilege, a deeply personal felt privilege. The second, my lord, I want to thank my senior, Mr. Venugopal. My lord, he's senior to me at the bar. He's the senior most at the moment, my lord, amongst us.
He is the senior most.
I beg your lordship.
He is the senior most.
He is the senior most. And my lord, it was his magnanimity and very kind permission that I could precede him. I acknowledge my gratitude. I acknowledge my gratitude to Mr. Kapil Sibal, who ensured that I could assist your lordships. And my lord, my wonderful juniors and colleagues who were, my lord, repeatedly urged to make the written submissions as accurate and as true to form. And my lord, to my learned friend, the Attorney General and the learned Solicitor General, for their courtesy and dignity. My lord, I'm here to answer any questions your lordships may have asked.
It's been a pleasure hearing you, because though we have been hearing all others here, for the first time that we are hearing you at such a length.
Only say, don't go back.
In last 6.5 years. For the good.
For the good.
It's good for the institution.
There's nothing better than this place.
I agree.
You would have realized now.
Yes, my lord.
I was in fact mentioning to Shraddhan that Mr. Subramanian is one of very few who retains the old graces of the bar. The fact that he deferred and allowed Mr. Sharma to address your lordships in the midst of his arguments when he was in full flow, it's not easy. The fact that he did that showed great.
No, and apart from that, sitting every day from 10:30 to 4.
From beginning to end, I think it's a great
He
example.
is the only person
Yes.
who has glued to his seat from 10:30 to 4.
Great example to everybody at the bar.
But my lord,
And the way he acknowledges everybody else.
But, my lord, I must also tell you, since two of your lordships are from Nagpur, my lord, I had the great privilege of getting from the Nagpur Bar Association a gift, which was a painting of Justice Vivian Bose. My lord, it adorned the office of the Solicitor General at that time. And, my lord, not only Justice Bose, Justice Hidayatullah, Justice Mudholkar, and then after that, my lord, we had Justice Sen, AP Sen. Lord, one cannot forget him. He was an extraordinary judge. And Lord, and now we have two eminent justices, Justice Bobde and my lord. So we have had
Justice Shirpurkar.
Justice B.S. Shirpurkar. Lord, one does not forget the bastions of glory in Nagpur. And my lord, the archives. I wanted to tell some of the younger lawyers that they should go to Nagpur and visit the archives, my lord, of all the manuscripts of the judgments from Leonard Stone onwards, who was a Chief Justice in Nagpur.
And written judgments also.
And yes, my lord. And my lord, I must also say the collected works of Dr. Ambedkar, which were published by the government of Maharashtra. The first chairman, my lord, of the editorial committee fortuitously happened to be Chief Justice's father. And my lord, it's a marvelous compilation of the works of Dr. Ambedkar. And my lord, he was magnificent in all fields of knowledge, anthropology, sociology, any form, law, of course. But my lord, he was a magnificent.
Around 30 volumes.
Yes, now it's 30 volumes. My lord, I'm ready. Any questions any of your lordships have? May I conclude?
Yes.
May I?
We are so comprehensive that we don't have whatever we wanted to.
Grateful.
We have not left anything to be asked.
I'm very grateful.
Yes, Mr. Venugopal is there on.
I will start by saying it was a pleasure listening to Mr. Gopal Subramanian. I had not heard him for a few years now because he was away in England. But I have filed my written submissions, which for a change, my lord, consists of only 8 pages. And if your lordship should go to volume 2.
Most concise so far.
Concise so far.
Yes, my lord. Only 8 pages. Volume 2.11. Pages 1291 to 1304, because it has 4 pages of, or 5 pages of annexures.
Yes, Mr. Venugopal, you can proceed.
Lord, your lordship, will you please return to page 1293.
Yes, we have it.
I set out Article 163, where, my lord, the word required has been highlighted. And the meaning of the word required in paragraph 2 is that it is essential, needed, necessary, compulsory, mandatory, according to Collins Dictionary and Vocabulary Dictionary. Now, if it is mandatory, then except insofar as he is by or under the Constitution mandated to exercise his functions or any of them in his discretion. And therefore, my lords, there is no single provision in Article 201 and 200 and 201 which requires him to exercise his discretion except in the second proviso. And therefore, my lords, my submission to your lordships is, so far as the entirety of 200 and 201 is to be a mandate to him to act according to its terms. Now, my lords, the second proviso says that as opinion, in his opinion, and that is the only area of discretion. It has been pointed out to your lordships any number of times. Other than this, the phrase, my lord, in the first proviso is as soon as possible. And as soon as possible is a subject matter of the judgment which has not been quoted, which is in para 4, General Insurance Council versus State of Andhra Pradesh, 2007, volume 12, SC 354. And if I may read that, para 8, use of the expression as soon as implies that there has to be promptitude in action. To do a thing as soon as possible means to do it within a reasonable time, with an understanding to do it within the shortest possible time. Per Assent J in King's Old County Limited versus Liquid Carbonic so and so Corporation. As and when and as soon as are almost synonymous. Whenever these expressions are used in respect of time and place, they denote contemporaneous notion as soon as and forthwith Both are to be normally understood as allowing reasonable time, but latter is more peremptory than the former. But urgency is a hallmark of both expressions. Expression as soon as may be stretched to mean as soon as practicable. It has to be forwarded with promptitude. And it cannot be read as soon as convenient, as soon as possible. And therefore, my lords, I would proceed on the basis that it should be forthwith. Now, the reason, my lords, why I say it should be forthwith is because even money bills, which are of the utmost urgency, and I will show the provisions of the Constitution, which would make it very, very urgent, that to show that he has to deal with it as soon as possible. Even if the phrase is as soon as possible was not there, if belongs a money bill is to be presented to him along with the other bills, he necessarily has to deal with the money bill instantaneously, forthwith, because the consequences of not assenting to a money bill will be stupendous. There is no question, my lords, of his having any right whatsoever to withhold assent to a money bill, which I'll presently show. And therefore, my lord, according to me, there are 5 choices. One choice, my lord, is to reserve the bills for the consideration of the President, which is covered by express provisions, my lords, of the Constitution. It's only in those cases that there can be a reservation.
According to, there are 5 choices.
It's 5 choices, not 4. And the 5 choices are: one, my lord,
Yes, one.
one is reference to, my lord's reservation for the President. The second is, my lord's, a money bill, which stands on a separate footing and independent of all the other bills. The third is, my lords, to grant assent. The fourth is, my lords, to refer, my lord, the bill with amendments to the legislature.
The third grant assent.
The grant assent. Then to refer the bill back to the legislature with a message. And the fifth, my lord, is to withhold assent.
So you are supporting the solicitor. The fifth option.
To a great extent, I may, my lords, finally, because I believe, my lords, that so far the governor is concerned, he has to play a collaborative role in granting assent. Please see, my lords, Article 199, the definition of a money bill.
Yes. Yes.
For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains